The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
You may be seated. We have 5 cases for submission this afternoon. The first 2 are oral, In the Interest of AM and Nelson versus Lindemann. The other 3 cases are non-oral, Vosagi, no one told me how to pronounce it, and Polishek, v. Polishek, State of Iowa versus Morris, and State of Iowa versus Thompson. The last 3 cases will be deemed submitted. And as you can see, Justice Cady is not with us this afternoon. He had a personal matter, but he will be participating in the cases by reviewing the briefs and the oral arguments. So we're ready to hear the case in the interest of AM. And Mr. Roehrick.
Thank you, Your Honor. May it please the Court. My name is John Roehrick, and I'm here this afternoon representing the appellant, Heather Thomas, although we've used her initials, and her employer, Arlie Ball. And 30 years ago, I stood here before this court arguing the psychotherapy privilege and whether billing records were protected by 622.10 and the constitutional right of privacy. Judge Needles at that time didn't agree with me, and neither did this court at that time on anything except the constitutional right of privacy, which Chidister versus Needles recognized. 30 years later, I'm back here again arguing the same privilege and the fact that mental health records are protected from disclosure via subpoena. But this time I'm arguing it in light of 2 additional laws. Number 1, Chapter 228, which is now specifically a confidential record law of mental health records, and also HIPAA, which is the Health Insurance Portability and Accounting Act. I think it's back in 1992. At that time, back when I was arguing Chidister versus Needles, the Chapter 622.10 comprised 1 column of the Code of Iowa, 1 column on a page of the Code of Iowa. It's now 3 pages long. We have not yet considered Chapter 226, but unless this court finds that Chapter 228, unless this court finds that it is more stringent than HIPAA, we're going to have to decide 115 pages of federal regulations as it relates to the protection of mental health and personal health information. This case started with an issuance of a subpoena by a guardian ad litem in juvenile court in Polk County, asking for the production of mental psychotherapy notes of Heather Thomas, who was a therapist at Arlie Ball. And they not only wanted the therapy notes, but they wanted the testimony of Ms. Thomas to come down to the district court and give testimony. As a standard operating procedure for Arlie Ball, which is a community mental health center here in Polk County, we filed a motion to quash and alleged in that motion that Chapter 228 primarily was governed and strictly forbade the disclosure of either therapy records or testimony without an appropriate release of information. And the release of information had not been signed by the patient. In fact, she ended up concurring in our motion, and she was the mother of the children at issue. We argued that Chapter 228 forbade the disclosure, as well as Chapter 622.10, and also HIPAA, arguing that HIPAA's rules and regulations with respect to the ownership, I use that word in quotes, ownership of the notes belonged to Ms. Thomas and not to the patient, and they were not protected health information.
Counsel, don't we also need to consider Iowa Code Section 232.96 sub 5, which
That's exactly where Judge Cohen went.
right.
In overruling, well, in sustaining our motion on the records, she upheld that we did not have to produce any of the records. But she did order that under 232.96 sub 5, that information was in fact admissible, and placed us in the position of saying, well, that may be true, but that would be on a question-by-question basis, and we think 228 trumps it. Chapter 228 trumps that. That's why we're here today.
And could you speak directly to why you think Chapter 220, or why we should find 228 trumps the more specific China statute?
Because the legislature, let's start with Chapter 228 overall. Chapter 228 sub 2 prohibits the disclosure of any mental health information without a release, save peer review, billing, scientific research, and family members. Those exceptions, which are spelled out in 228.2, say that but for those circumstances, it may not be disclosed. Then you jump down to 228.6, and that's the section that's in conflict with 232.96. 228.6 says the records are not admissible except in chapters 228, 229, 230, and it enumerates the civil commitment, and et cetera, the chapters for which they would be admissible and disclosable. And it specifically says 232.74 and 232.147, I believe. Those two sections, basically, nobody, I think, would argue that it doesn't make any difference in those situations with mental health, because the first one relates to child abuse. It relates strictly to child abuse and the fact that the confidentiality privilege does not apply. And 147 is just a broad general confidentiality of juvenile records. So the legislature, when it passed that statute and amended it as late as 2011, left alone 232.96.5, indicating thus that it was still to be excluded. Because when they did amend 226.6, they added 5 exceptions in addition to the name chapters. They said if it's a claim or a defense, they can get out. If it is a criminal case, they can get out. They conform 228.6 to the rest of the code, particularly 622.10, and those sections that the legislature took care of following this court's decisions in Heemstra and Ashenfelter, et cetera.
Could you address an argument that 232.96 sub 5 is more specific because it's this type of case? It's a China proceeding where the court has to determine what to do, what the best interests of the children are, et cetera, and it provides that the privilege for mental health professional and patient shall not be a ground for excluding evidence at an adjudicatory hearing. Isn't that more specific for today's purposes than the general confidentiality of Chapter 228?
Of Chapter 228? Oh, I think, Your Honor, that 228 is very specific in saying it shall be. It's almost an absolute bar to disclosure, save when the legislature carved out exceptions. The other side of that is we still walk right into the face of the constitutional right of privacy. And that was settled in Chidester versus Needles and has been expanded over the years. So the legislature, cognizant under the rules of construction of the constitutional right of privacy and the broadening of that constitutional right by this court with mental health records, and recognizing the Cashin and the Ashenfelter and the Heemstra decision, and amending 228.6, left it alone. saying, we think it's still accepted. It may be very specific, but we're leaving that alone because it is excluded under 228.6.
Did the mother put her mental health at issue to bring her within the patient litigant exception to 228 or 622.10?
No.
And why not?
Because, first of all, the records were subpoenaed by the guardian ad litem. The mother did not give a release of information, and she concurred with us in quashing the motion to quash. There was nothing in the record that speaks to her mental health status being an issue within the case.
But didn't she provide a letter from the therapist saying that she'd been attending therapy and showed engagement in it and so forth? Doesn't that kind of put that in issue?
She had given a release of information to the Department of Human Services, and that is to whom Ms. Thomas directed her letter. Under that release, she had not given a release to permit any information or therapy records to be given out by Ms. Thomas. So when she received the subpoena, not having a release for what they wanted, which was her notes, and for her appearance, the motion to quash was filed.
Once she releases the records to one party, though, for the same transaction or in the same transaction, doesn't she lose the privilege to the other parties?
She did not release her records or permit testimony. She asked for a report. And I honestly haven't seen that report because it was never introduced into the record.
Isn't it sort of like when you take the Fifth Amendment, you can't just take part of it and the rest of it you either have to release all the information or not release all the information. You can't pick and choose what records you're going to release and not release.
But you can pick and choose to whom you're going to release those records. That's the reason for the release of information.
But I don't know about that. There's sort of in the reliance of counsel field, a party can't say, well, I relied on counsel in this transaction and then decline to say what advice counsel actually gave them. And here it's kind of like that. The mother says, well, I'm getting therapy and therefore I'm doing better, I can handle the kids, but they're declining to disclose what actually was going on in that therapy or what the therapist's view of how she was performing was.
That's the purpose to seek therapy, to seek treatment without fear of having that divulged. And the release of information, although it's not on the record, to the best of my understanding, was just to release information as to her attendance. But that was never made part of the record, at least part of the record that got here.
If we compelled the testimony of the mother's therapist in this case, would it have a chilling effect on the willingness of other patients to open up to their therapist?
This is going out way outside the record, Your Honor, but my experience is absolutely, because our folks are then going to be placed in the position of advising every time one of them comes in, a patient comes in, that what you're telling us today may not be protected, and we may be compelled to disclose it. And that's going to shut down.
Okay. And confidentiality is vitally important to have a good therapeutic counseling relationship.
Absolutely.
Right?
Otherwise, people wouldn't come there.
On the other hand, we've got the court has to make a determination of what's in the best interest of the child, and isn't the mother's mental health condition and her fitness highly relevant to that determination? Then
under Mulligan, I think it's the Mulligan case, the court has that opportunity at the very beginning. And it's the progeny, basically, of State versus Cole back in 1979 or 1980. And that is, the court can order the parents into therapy. Then it's not privileged.
Can we do what we do in the self-incrimination area in civil cases? In a civil case, you're allowed to assert the right against self-incrimination, but at the same time, it's presumed that if the question was answered, it would be to your detriment. Can we do the same thing here. If she's not willing to release her records in order to look to the best interest of the child, can we make the same presumption that if the records were released, they would be against the interest of the mother? And that's not requiring her to release the records. It's just making a presumption like we do in the area of self-incrimination in the civil area.
That's what we do in the civil area, right, with the right of self-incrimination, no question about that.
This is a civil proceeding.
It's a civil proceeding, very different civil proceeding, because you're talking about the rights as a parent. And if you start to presume because they exercise one protected right, and what's more important, the inference or the fact that the parents get the therapy?
The rule applies in a dissolution case where you're dealing with the rights of a parent to get custody and to do all those things. We apply it there too.
But you can't come and get the medical records.
No, but if you take the privilege against self-incrimination, in a custody thing, it's presumed the answer to the question would be against your interest.
It's still far different, Judge, when you break it down from the self-incrimination to the right of the parent to have a presumption used against them. And that then is really affecting them constitutionally. Not in our record. It's not in our record, but it's constitutionally, because they're having an inference used against them because they exercised one of their constitutional rights under the way this court has ruled of the exercise of the psychotherapy
Right
privilege.
against self-incrimination is a constitutional right you're exercising. So the same thing happens. Anyway, I see your time's up. You might want to sum up.
Okay. Thank you, Your Honors.
Sum up if you want for a second.
Well, I didn't get to the HIPAA, but that's the big elephant in the room. If we don't find Chapter 228 to be more stringent than HIPAA becomes the controlling law in Iowa. And that opens up the door to who knows what with respect to self-incrimination type inferences or whatever. And so we're urging that 228 be found to be more stringent, and we're going to apply state law rather than federal.
Thank you very much. Ms. Saveraid, do I have that right?
Saveraid, thank you, Your Honor. May it please the court, Your Honors. My name is Michelle Saveraid. I'm an attorney with the Youth Law Center. I represent the children at issue before the court today. Your Honors, with all due respect to Ms. Thomas, I would submit to the court that this case is not about a subpoena compelling her testimony. In fact, this case is about an 11-year-old child and her 5- and 3-year-old siblings who were removed from the custody of their parents back on May 29th of 2013, nearly a year before this issue of Ms. Thomas' subpoena came before the juvenile court. This case is about 3 children who were exposed to ongoing methamphetamine use, domestic violence, and struggles of their parents with mental health. Most importantly, however, I believe that this case is about the juvenile court's requirement to protect children from those instances. And I believe that that protection is mandated by the courts under 232 generally and specifically in 232-102 sub 5, which outlines that the court must provide reasonable efforts. Before I get into that, I do want to point out to the court that I think that, as Appellant has pointed out, certainly considering this case does involve weighing all of the very important cases dating back well before I was practicing law. I think, however, what the court must consider is those cases under the unique lens of juvenile court, which I don't think any case has done to this point. And I think the Ashenfelter-Mulligan case is about as close as this court's gotten to that issue. I don't believe that, I would concede that I did not raise in my response to Appellant's brief 2 important things. I believe that the appellate did not preserve the issue of constitutional arguments at the juvenile court level. I don't believe that was something that Judge Cohen considered, and as such, I don't believe that that's properly preserved for appeal. Additionally, although the appellate did raise a HIPAA argument, there were no findings based on the applicability of HIPAA in Judge Cohen's ruling. Appellant certainly did not file a motion to enlarge or expand, and I believe as such he's prohibited additionally from making those arguments here. I want to...
I mean, Isn't HIPAA, to kind of boil it down, if the court orders it under HIPAA, you have to do it, and therefore we really need to focus on state law rather than HIPAA?
I certainly believe that's accurate, yes, Your Honor. I want to be clear with the court today that from my perspective, this case is not about the production of Ms. Thomas's therapy notes. In fact, as Mr. Roehrick pointed out, the court ruled in his favor on that issue. I did not appeal that issue. My record before the court made clear that in fact what I was seeking on behalf of the children was the testimony of Ms. Thomas that would aid both the parties and I believe ultimately the court in making a decision about whether or not mother in particular had remedied the things that the court herself had made findings about. And I would take exception with the argument that mom did not put her mental health at issue. As the court can tell from my brief, there were multiple findings by this court after hearing the testimony of mother about her shortcomings in terms of her credibility, her ability to protect her children, her insight about both her substance abuse and father's substance abuse, as well as the history of domestic violence. The court specifically ordered that mother have therapy, not only therapy, but trauma-informed therapy, and made some specific findings about how she needed to address those issues to improve her insight and her ability to parent. And at that time, the children were outside of her custody. The court then, at each time that we came before it, had to revisit whether or not reasonable efforts were being made. Mother acquiesced in that she was, in fact, participating in the services, the therapy that was provided, and she did, in fact, provide her own therapy letter outlining her attendance at court.
Were those issues that you've just itemized addressed in a written report, though, from the therapist that was authorized by mom?
To what issues do you refer, Your Honor?
Well, the ones you just listed a whole bunch of them. You know, the fact that she was supposed to have trauma therapy and she was and was supposed to be attending regularly and making progress and so forth. Were those concerns that you just listed addressed in a written report from the expert prior to the time you subpoenaed her to come and?
They were not, Your Honor. The only information received previously from Ms. Thomas was a list of dates that the mother had, in fact, attended therapy, and I believe that dated back to November of 2013.
Okay, so that reflected regular attendance, did it?
I think it did reflect regular attendance at that point. I can't speak to her attendance after that because there were no additional records provided even by mother as it relates to her attendance. I think it's important to note, though, that the Court of Appeals in the TMCM case indicated that mere participation in services isn't tantamount to providing a safe environment for children, and that what courts really need to be able to make a finding about are those things that are enumerated in 232.102 subsection 10A, which are the type, duration, and intensity of services both offered and provided to families. Those are the things that the code outlines the court has to weigh in making reasonable effort findings, and that all reasonable...
I just have a question. I'm sorry to interrupt, but I just have a question then. I sort of got the impression from Mr. Roehrick that this wasn't court-ordered. Are you saying that this was, in fact, a court-ordered, and I'm looking at 228.6 on the compulsory disclosures, are you saying that this was a court-ordered examination and or treatment?
Your Honor, I don't believe it was a court-ordered examination. However, mother was court-ordered to participate in therapeutic services. To that end, Your Honor, I believe that Mr. Roehrick, there were some questions asked.
What does that difference mean?
Well, I don't think it fits neatly under that exception. However, I do think that this disclosure does fit within 228.6 in that catch-all phrase at the end, which permits the disclosure to further any state or federal law involved with human health and safety. What could be more involved with health and human safety than our Child in Need of Assistance statute, Iowa Chapter 232, which, as the Justice has pointed out earlier, I believe is much more pertinent and definitive to this very question. Disclosure in a Child in Need of Assistance case to the very issues that the court has identified and that mom, quite frankly, acquiesced in. Mom didn't appeal any findings of the court that her mental health was at issue. She had never asked for any other services to address the mental health issues that the court had identified. excuse me. And in fact, she provided information to the court that would have purported to show that she was complying with those services. The information I sought was that substantive information about the type, the intensity, and the duration of those services, and whether or not they in fact met those shortcomings that the court had identified and that these children had clearly suffered from as a result of growing up in the parents' home.
When I was on the Court of Appeals and saw a lot more of these kinds of cases, it seemed to me it was common that the treater for the parent would come in and testify. The parent would want that. This is unusual, isn't it? I mean, just as a...
It definitely is. This is the first time I've been here, and I've been practicing for about 11 years. I will say that it is very commonplace for us to have testimony from therapists, children's parents, and not ever have these issues. I would have to assume, although I've not inquired, that those therapists have been satisfied with whatever release has been signed or whatever order of the court has been issued requiring their testimony. I can also tell the court that the juvenile courts in Polk County, where I primarily practice, regularly expect that either the state or the guardian ad litem is getting meaningful reports from therapists, both children and parents therapists, and if those meaningful reports aren't forthcoming informally, as our discovery mandates, then they expect us to subpoena those people to come to court. And just anecdotally, I'll tell the court that the majority of the time we issue a subpoena, we just get a report. We're not arguing about whether they're going to come and testify. And those reports usually suffice to answer the kinds of questions that courts have to answer about whether or not reasonable efforts are being met.
Isn't the court authorized to compel the testimony under Code Section 232-96, sub 5?
I absolutely believe it is, Your Honor, and I believe that's what Judge Cohen found in this case and is regularly what's happening in our juvenile courts.
And if we decide if we affirm on that basis, then do we need to decide whether the mother put her mental health at issue or not, or does the statute just
Your Honor,
compel disclosure regardless?
I don't believe that code section requires that if the court goes further and examines 622.10, then I believe that question does need to be answered, although I would say 622.10 is a little bit troublesome for me in terms of how it really fits with juvenile court. I don't necessarily consider myself an adverse party to parents. I don't believe that's what the nature of our juvenile court proceedings are. Certainly there are times when it comes to that, but I don't believe that that's necessarily the nature of those proceedings. I did want to address the chilling effect that was asked, I believe, of you, sir, earlier. I think that an assertion that there's some sort of chilling effect by us introducing these records assumes that they are intended, that that information is intended for some reason other than what is already known. We're not looking for therapy records going back 3 years before a child in need of assistance petition was filed. What we're talking about is an identified deficit and a service that's targeted to address that deficit and some sort of ability to measure whether or not they have addressed those concerns. My experience generally is parents are willing to give us that information if it in fact shows that they're making progress.
Was your subpoena that narrowly drawn? Or did it just say, bring everything you've got?
My subpoena requested her presence at court with attendance records and her psychotherapy notes. And as I indicated on the record...
Unlimited, as far back as
You're right, I did not. It had been my belief based on Ms. Thomas's prior report to the court that there was only services provided during the duration of our China case. So I did not limit that in terms of the date. That's correct.
With the testimony, are these hearings in open court with people allowed to listen in?
Your Honor, juvenile court is open. However, the court does have the ability to make requisite findings to close the courtroom. And I would suggest to the court that that's one of the unique abilities of juvenile court to address exactly the issues that may play into whether or not parents are willing to engage in those services. Additionally, the juvenile court judge is the sole finder of fact. They have the ability to review reports in camera and make appropriate decisions about the protective or sealed nature of those exhibits going forward.
I kind of want to go back to what Justice Wiggins was talking about. Obviously, this happens all the time because you would think that people are going to have a favorable report that they have been attending, they are seeking the treatment that the court orders. But what if they just say, I don't care, I don't want to have my therapist come testify, and, is it, we try to maneuver the rules a little bit here to require them to come, but isn't it kind of a choice of that person? What's going to happen, of course, at the China adjudication is that they're going to have, you can say, oh, I've been going to these things, but you don't have any evidence to support it, and, you're kind of cutting off your own, cutting yourself off in that type of hearing. But I guess if that's their choice and they're going to lose their kids and they want to do that, what's wrong with that, I guess?
I will say I think that is absolutely what does happen. Is just a matter of course that an inference is made by the juvenile court judge that there must be something that isn't particularly favorable to that parent. The majority of the time we're seeing this well after adjudication, because that's arguably when we're offering the services for the first time and they're beginning in those services. But I think that is likely what happens, and I think that could likely be a result of what's before the court today, that this court says, we're not going to address whether or not there's mandatory disclosure based on the statutory scheme in front of us, but parents can decide, and if they don't want to, then courts can make that inference. It's quite honestly what we do on the front of urine drug screens and drug testing in juvenile courts here in Polk County, at least. Services are offered if the parents don't utilize them. If they miss the opportunity to do that, the courts regularly consider those to be positive drug screens, and that's something that's well known to everyone that participates in the juvenile court system here.
If we affirm the order compelling the testimony, could we condition it on the court being closed to the public and this being done privately, or just the judge and attorneys and parties hearing it?
I believe so, and I think that would absolutely be a grounds that, in my experience, courts have been closed to the public previously. Absolutely. In closing, I just want to suggest to the court, as I think I've done through my argument, that if opposing counsel's argument regarding the statutory construction is in fact true, then I think what we really do is require our juvenile courts to make findings that are necessary to the preservation of families without some really meaningful information. I don't think that's what the legislature intended or this court intended, given the priority that's placed on immediately addressing the concerns that arise for the children in this state and returning them as soon as possible to a safe and loving home. Thank you.
Mr. Roehrick, do you have any rebuttal?
Yes, Your Honor. May it please the court. First of all, there was no, I'm going to just say this and leave it because there's some other issues I want to cover, but there was no preservation of error on those very issues. This was whether we're going to issue, Ms. Thomas is going to come in and testify and bring her notes with her as well as her attendance records. In fact, the subpoena is very specific. There's to be therapy notes and attendance record. So it wasn't just limited. The subpoena was not just limited to her attendance records. It was a request that she bring her therapy notes with her as well. So that brings us right back to the issue of the exercise of the privilege. If this court wishes to say that 232-96-5 trumps Chapter 228, then this court is going to end up having to decide whether 42 CFR 162-513, which is the psychotherapy privilege, trumps Iowa law, which it does. It preempts. It's federal law, it preempts the state unless this court is willing to find that Chapter 228 is more stringent than HIPAA. If it allows 232-96 to come in through the side door, then you've opened the door up to HIPAA.
Could you speak to the question whether HIPAA permits disclosure if there's a state court order?
There's a specific procedure, a state court order. It's all these are all state, Your Honor. But the thing is, it's the medical records that there's a specific procedure under HIPAA for doing that, which we sort of have under 622-10-5, where
but here they've conceded they're not asking for the records; it's the testimony
and the records. The subpoena was for the records as well, Your Honor. We didn't prepare that because under the court order we were not to prepare a record. But if the court goes into and looks at it, it was therapy notes. It was, and attendance records.
But then the court didn't compel disclosure of the notes, it compelled the testimony, right?
Yeah, but I don't know how, frankly, Judge, you can do one without the other. It's a hand in glove. How can I give my testimony without my notes? Because, okay, so that's where we end up at. Mulligan is the perfect example of how, if juvenile court wants that information, it can get there. It can order a court-ordered examination of both parents, or one parent, to determine that mental health condition. And then it is not therapy. It is a court-ordered exam. That goes back to State versus Cole. And Ms. Cole's claimed that her therapist's notes were not allowed because it was to determine whether she was competent or not. And this court said, no, absolutely not. That was a court-ordered exam. That's what Mulligan provides. That's what 622.10.5 provides.
What about the argument that this was therapeutic services were ordered?
Judge,
just therapeutic services?
I can't speak to that. There's no record of that. It was not offered at the time of the hearing. I couldn't even respond to Judge Cohen. It never came up.
Is it in the court file that's up here before us?
I don't know if it's in the court file or not, Your Honor. This was submitted without record. So I don't know what this court has. I have not seen the court file. I'm not a party to that. I'm sort of coming through the side door because of the therapist. I'm sort of like in the case where the mother gave consent in a divorce case to the records, to the children's records. The dad gave consent. The therapist says, no, I'm not going to do it. And this court said, you're right, you don't have to. But so we get back into the fact that Ms. Saveraid is an adverse party here. She really is, as a GAL. So when we come in under 622.10.2, if we're going to go down that road, claim or defense, she is an adverse party. The procedures were not even followed. We would have a much better record, Your Honor, if 622.10 had been followed here, and that is the application for the court to issue the subpoena, which would then have given the ability of the mother to come before the court and say, I don't want them, and why, allowed us to come in as the therapist and the custodial of the records to do that, and then Judge Cohen could have made her specific findings. There is a procedure for it. It wasn't followed. And so we still get back to the point now of how expansive we're going to make this privilege. And the argument that 228.6 permits it for health and safety welfare, that's in reference to the mandatory child abuse reporting and if a crime is divulged, the mandatory reporting of that. So, a conclusion, I was here 30 years ago. I don't want to come back in 30 more years and argue this same privilege. So I'd ask the court to overrule and hold that the privilege is sacrosanct. Thank you.
Thank you. The case is now submitted, and we'll move on to the next case of Nelson versus Lindeman.